So today we're going to talk. This panel is going to be about judicial obstruction of immigration policies or intervention, however you want to see it, or just interpretation. So we have esteemed speakers. We have Matt O'Brien. He's a deputy executive director of the Federation of Fair. We have Simon Hankinson from the Heritage Foundation, and we have Victor Marasi from the Migration Research Institute from Hungary. Very nice to meet you all and be on this panel. Every one of the speakers is going to speak about the same issue, but from a different area or zone. So Matt, if you can start, please, speak about the situation local, right, here in the U.S. Please. Thank you.
Sure. So when Mark asked me to do this, he said, can you talk about judicial obstruction? And I said, how long do I have? And he said, 10 minutes. And so this is kind of like when you're dealing with an audience from a completely different legal system, it's like trying to explain God to a 5-year-old in 10 minutes or less, but I'll do my best. So currently, there's about 223 active cases challenging Trump administrative actions, most of them having to do with immigration. Now, in a sense, this isn't particularly surprising. In his book, Democracy in America, Alexis de Tocqueville, or as we brutalize the name, Alexis de Tocqueville, famously observed that scarcely any political question arises in the United States that is not resolved sooner or later into a judicial question. So that observation highlights the sort of unique power that the American judiciary has. And it's even somewhat unique in terms of other common law countries. So the Supreme Court here has the authority to rule on the constitutionality of both laws and executive actions. Now, on the positive side, that can be a check against tyranny. And on the negative side, that can lead to judicial activism, which is legislating from the bench, or to legal instrumentalism, which is using the tool of law as a tool for imposing social policy on the basis of the judge's personal political views. And it's also the process of divorcing the law from any kind of moral guidance. So when we take a look at what's really going on in America's courts when it comes to immigration, we have several things that have all converged to make it possible for the court to stand in the way of the executive branch executing laws that were passed by a duly elected legislature that had every bit of authority to pass those laws. So we have the emergence of the administrative state. In essence, Congress has abandoned its legislative function in favor of oversight, and as a result, it's acting more like the executive. Instead of making laws, it holds hearings, it dictates things to agency heads, but it doesn't address any of these issues via legislation. In addition, as a result, the executive branch has been acting more like a legislature. So it passes regulations and policies, none of which are particularly durable to govern how we deal with the immigration situation. And then you insert in the middle of this a problem which I think is probably everybody here understands, which is career functionaries, or as we have begun calling them in the United States, the deep state. And so these are people who are career government employees. They never change when the administrations change. They have whatever political views they hold. They're not necessarily aligned with the political administration. And they have a tendency to apply laws either, more broadly or more restrictively than the actual statutes require. And those decisions frequently wind up being incorporated into precedent by judges who don't particularly know anything about immigration law. And if you stop and think about this from the perspective of judges in American courts sit in what are called courts of general jurisdiction for the most part. So they're expected to deal with any issue about anything that comes up in law. And so that means that you have people that don't necessarily have expertise in any one particular area of law. They tend to be jacks of all trades. And that differs a lot from Europe, where I was shocked the first time that I went to the Conseil Constitutionnel in France and found, I asked how many justices do they have, and they said, justices, how many chambers? And, there's a number of specialized chambers that deal with specific issues. So from a purely practical legal standpoint, pretty much everything currently being done by the Trump administration has been in U.S. immigration law since the passage of the 1965 Immigration and Nationality Act. But multiple administrations, both Republican and Democrat alike, have decided that they didn't like those particular parts of the law. They were attempting to appeal to some type of political constituency and just ignored the law and did what they wanted. And a perfect example is there's a recent case that came out from the Board of Immigration Appeals talking about bond for illegal aliens. Now, bond is when individuals that are in custody in the United States are released on the payment of a fee, which they get back if they show up for their hearing. Well, illegal aliens have never, ever been eligible for bond in the United States, and the government decided to give them bond in circumstances that Congress had specifically forbade it, and the federal government never bothered to raise this issue in a court until just recently. We have a problem with judicial activism, as I mentioned before. The function of a judge in the common law system is to take the law, read it, determine what it says, and then apply it to the facts of a case. Judges are not supposed to act as general purpose umpires and just decide a case based on their own political and moral leanings. And if you're following any of this in the U.S. media, you may have seen situations with Judge Boasberg in Washington, D.C., and Judge Sarah Ellis in Chicago, Illinois, and both of them have been actively engaged in trying to manage their removal process. They've given direct instructions to federal agencies about how to do things, which really is not the role of a judge in the U.S. And then, of course, you have judges according due process rights to aliens where no such rights actually exist. You look at the Kilmar Abrego Garcia case, the gentleman who was described as the Maryland Dad, who wasn't. He was a gang member and a human trafficker. And then we have legal instrumentalism, which is a theory that has crept into the U.S. courts over time, which is that law doesn't have anything to do with a general perception of morality. It is an amoral tool for governing. And so whatever administration is in power, whatever the popular will is, should be what the courts reflect. And that has led to a tendency to try and revisit already settled matters. Trump v. Hawaii was an interesting case that happened here in the United States. The Supreme Court said the president has, according to American statute, the ability to close down the border in response to special circumstances. This is something that was unquestioned. There were about 6 or 8 major cases that the Supreme Court had held this, and yet somehow this still wound up in court simply because people did not like the fact that President Trump had employed the power. We have a problem with forum shopping, where people look for a particular court. The United States federal court system is divided into judicial circuits. Judicial circuits, when they have reasonable interpretations, can differ on how they apply the law, and a lot of the people involved in immigration have gone to the Ninth Circuit, which covers California. It's the most overruled circuit in the country, and it's most frequently overruled on immigration matters. And so most of these cases we have seen start there. And then, of course, we have the problem of lawfare, which is the deliberate misuse of a legal forum as a tool of subversion. And a lot of what's being done is these cases are brought in the courts in order to spread a message about what is being argued about. For instance, illegal aliens deserve bail. And the outcome of the case really isn't the issue. It's an attempt to get this into the media and have it discussed. Now, slowly but surely, the Trump administration is securing victories in the Supreme Court. However, that process is slow, and there's a very limited time window in which to secure our borders, remove the massive number of illegal aliens that have come into the United States, and right the ship. And we have a tendency to think about these things in 4-year terms. But here in the United States, if you have the White House but you don't have the legislature, then you really can't do anything. And if you have the White House and the legislature, but you don't have a supermajority in the legislature, then it's extremely difficult to accomplish anything. And then you add to that the way electoral politics in general have started to go in the United States. Most legislators, the individuals, are hesitant to actually pass any legislation because they don't want to offend anyone, because the electoral margins are so slim in so many places that in order to stay in office, they need to make sure that they kind of are white paint like on the walls of this room and completely inoffensive. So, despite all of those problems, Trump v. Hawaii was a major victory. The Section 1182F of the Immigration and Nationality Act really affirmed the president's ability to control the border. There was a recent case called Perdomo v. Nome, where there is a standard called probable cause in U.S. law in order to effectuate a criminal arrest. Civil arrests are generally judged by a different standard. It's still probable cause, but it's slightly different. Well, a judge in California didn't like the raids that ICE was doing at locations where illegal aliens congregated looking for jobs and put an injunction in place and imposed the criminal probable cause standard for arrests, but called it reasonable cause. Trump administration prevailed on that. And there was also a case called Nome v. National TPS Alliance. TPS is temporary protected status. It does sort of what everyone thinks that refugee status does, which it allows for temporary protection of people who are experiencing civil strife in their countries or natural disasters. Temporary protected status, despite the name in the U.S., has not been temporary at all. There are people who have been in the country for 20 or 30 years based on earthquakes that happened in the Caribbean ages ago that are no longer a threat, and they have been permitted to stay in the U.S., and because of political pushback, no one wants to revoke the TPS. And so the Trump administration, for the first time, did that. And so what we have is a situation where all of these things should belong to the executive, and the executive should be fulfilling its constitutional commitment to enforce the laws, but it hasn't been. And now it's been left up to the courts to try and fix these problems, which is the last place where we want to have them.
Thank you, Matt.
Thank you.
Victor, you can speak about the situation in Europe.
Yeah, ladies and gentlemen, thank you to be here. Thank you for our American partners that they organized this wonderful event, and I'm very happy that this time not only 5 members of the INE are here, but the 6th new member of FAIR. So it's a real privilege to be here. At some point, I will continue what Rodrigo mentioned about this whole European Union context, and a lot of other topics have been already mentioned or raised in the previous panel, or even in the speech of Matt. So a little bit I would like to conceptualize what's going on in the European and the EU context. So first of all, there's no any surprise what's happening in this judicial branch and why they try to expand their power, sometimes in the framework of this competence script, so not always very openly, but sometimes hiddenly. It's in general in the nature of the European Union since the first treaties. The ever closer union is an agenda for the member state and the institutions. What I think changed in the last, let's say, 20, 30 years, and mainly after the Treaty of Lisbon, that somehow the power of the institutions reached the critical mass, which can compete with the power and the influence and sometimes the sovereignty of individual member states. It's very clear if we just have a look on the fight, battle, marriage between the Commission and other EU institutions and Hungary. And if we have a look at the judicial branch and consider, this separation of power, mentioning other famous scholar Montesquieu. So what's relatively new on this separation, that the judicial branch, both the Court of Justice of the European Union and the national judiciaries could not resist to the temptation of two things, to be political and became more activist and sometimes ideological. And it's very important to make distinction between the two, because sometimes they are more political and sometimes they are more ideological, and there is sometimes contradiction in these approaches. It was very clear, for example, in the case of Hungary, that it was a political decision from the court when they decided, Hungary was fine because it limited the access of asylum seekers to its asylum system, according to the ruling of the Court of Justice of the European Union. And the Commission, the guardian of the treaties, offered for the Kurds a penalty for Hungary, 7 million euro one-time penalty, another 16,000 euro daily, which, okay, it's for me, I would be happy to see it in my bank account, but in general for Hungary, it was not a big case. But the decision of the court was to increase this 7 million euro to 200 million euros. So it's almost 30 times more. And to increase this 16,000 daily penalty to 1 million euro. What Rodrigo mentioned, so it's the second case, 70 times more. And yeah, it's a huge amount of money, and it was not influenced by really the Commission. Even the Commission, I don't know what was your experience, Rodrigo, but taking discussion with the guys, they were even surprised that, oh wow, we managed to reach much more, the court managed to reach much more what we as the Commission tried, and it was simply a political decision from the part of the court, to make pressure on Hungary because of certain well-known reasons. In the ideological front, we can see this, we call it in Hungary as a humanitarian fundamentalism, which was touched almost each speaker, this panel and the previous one. And perhaps one of the biggest challenges that we can see the language of the European Union and the treaties and the recommendation, etc., as a Trojan horse for to soften up the whole border regime, asylum regime of the European Union, and thanks to the treaties to the member state. When we are speaking always, the best interest of children, and then we are on the topic of family unification, the possibility of deportation, or what certain member states can do the child or children and families where the parents are illegal immigrants, their asylum seekers, asylum requests were rejected, but actually the kid was born in the member states, and some member states, birthright citizenship there also. So it means that they can stay, like in the other side of the pond, as we discussed. It's also a problem that in many cases the debate is derailed by the court from the original track and the original topic to absolutely other topics. It's the recent ruling of the Court of Justice of the European Union about this Italy-Albania deal was a typical example about this. The original concept was the part of Italy, to stop the boats in international waters. They tried to processing the asylum request of persons who were stopped on the Mediterranean Sea, not in under Italian jurisdiction. And the plan was to bring persons to the Albanian processing centers only whose asylum claim was likely rejected, because they're coming from safe third countries or countries with very limited acceptance rates. But it would have meant that there would be a process, an asylum process. So there would not be an automatic deportation process or automatic rejection of their claim. Just it would be a shorter and more concentrating process, because not only in the United States, but also Europe, the processing, the asylum requests takes perhaps not 6 years for the first court hearing, but 1.5, 2.5 years. Okay, so what was the ruling actually of the Court of Justice of the European Union? Not about the processing, and indeed they pretended that there will be no processing in Albanian centers. So they ruled that no, it's completely against EU law because so say the list of the Italian government on the safe third countries is not good. It's not eligible to the EU regulations, because the safe third country has to be safe for all people who's living there. So we could see also widening of this whole legal framework because just consider that which is the country which is safe for all people who is on their territory. There's no such kind of country. I can be hit by a car if I go out from this wonderful building. So, but actually it meant the end of the whole case of the Italian-Albanian agreement. We can see also double standards and selection how to interpret certain treaties, because we mentioned the different EU regulation and the European Convention of Human Rights, and there is the third Article 3. No one shall be subject to torture or to inhuman, degrading treatment of punishment, which means actually European countries can't deport people back. Many countries around Europe and countries of origin. Let's consider Afghanistan, which clearly is the country is under Taliban. Okay, and this partly the why Hungary was, fined by the Kurds, that we try to send back people. Countries which is considered not safe, according to the Commission and the Court. And I don't know whether you have seen that it was just 1 month ago that Germany managed to deport back people to Afghanistan. There's no any issue about this from the side of the Commission or the Kurds. This is why I'm telling that sometimes it's political decision, it's not ideological decision which country is under, attacked by the Kurds. And again, it's the Article 8, of the convention is about the right for family life, etc., etc. But it also contains, that it can't contradict the right for family life and individual life. It can contradict to national security, well-being of the citizens, the democratic values, economic gains, etc., etc. So actually, what Jonathan mentioned in the case of Geneva Convention, so it is in the treaty. What we see now that actually illegal mass migration is affecting security in Europe, national security, economic well-being of the citizens. But surprisingly, nobody is quoting it when deciding, oh no, it's about family unification or any other topic. And about the double standards, perhaps the last example is the fences, which was also mentioned by Rodrigo. It's an absolutely insane situation that still there is a strong resistance for certain countries, the EU institutions and the court itself, to support to building physical barriers all around of the European Union to protect the Schengen zone from mass migration from the Western Balkan or from Belarus. Just a minute. And still, Hungary is under strong attack. That even the court, was not so happy about the Serbian-Hungarian border fence. Why? If you check the news again, Ursula von der Leyen, the head of the Commission, just made a speech together with Donald Tusk on the Belarusian border with behind the fence. So, yeah. So I stop now, and if there will be a question, I will answer for this. Thank you.
Thank you, Victor. Simon, if you can speak about the UK situation.
Sure. Now, I'm a reluctant researcher. I'm much better at a bumper sticker or an op-ed, so forgive me if I go at a rather 36,000-foot level. And although I'm English by birth, I'm not an expert on the UK situation. I've been looking into it lately, and the deeper I got, the more I came to a pretty simple conclusion, which is that in this struggle we're in between globalists, people who believe in an international right to migrate, essentially open borders, and nationalists who believe in nation states that get to decide, as Deputy Secretary Landau said, the rules, who gets to come in under what circumstances. The West, the North, the developed countries are essentially, they're committing suicide by law. And that's the big picture. So it's not just a question of ending the abuse. And I'll get into some details about the various laws in the UK that make it easy for people who should be deported on every moral ground to remain. That doesn't change the course. I mean, let's just take some hypothetical figures. Let's say in Germany, 40% of asylum cases are approved and they only deport 10%. Okay? And in the United States, we always talked about, we got to process these cases faster. Well, let's say they processed all the cases within a day, and then they deported everybody who was deportable within another day, within 48 hours. The supply of people trying to get into Germany and the West for economic reasons, using asylum as the guise, and I'm not denying that there are some genuine asylum cases in there, but that supply is infinite. So what is 40% of an infinite number? It's infinity. So just gearing up the system and eliminating abuse does not solve the basic problem, which is that there is an over demand of people trying to get into Western countries to have a better life, and there is a limited supply. So nothing is going to work for the United Kingdom, which is what I'm talking about, except changing national laws, pulling out of the European Convention on Human Rights, and ending the idea that everybody who wants to be able to claim asylum deserves to be heard and to have the possibility of getting asylum. Britain is a country of, I think they're pushing 70 million now, and I was just there a couple weeks ago. It's getting pretty crowded. I mean, is it going to end up like Hong Kong? Is that the idea? At the current rate of progress, I would say that's their future. So to use an analogy from a movie, Titanic, you know, there comes a point where the lifeboat's built for 20, you got 25 in it, and someone's swimming towards you, and you may have to decide that Leonardo DiCaprio doesn't make it to the end of the movie. Now, I know that sounds glib and cruel, but fundamentally, I think countries in the West, developed countries, are going to have to reach this philosophical moment where they conclude that just as right now today we're sitting in this room nicely dressed and with temperature control, and we'll have a nice meal, we've had some coffee, we all accept that there are people in the world whose lives suck. I've lived in 8 countries, I've traveled around the world, I've been to places where people's lives are significantly worse than they are here. And were I to devote all of my resources, I might be able to help, you know, a handful of them. But I cannot alleviate all of that suffering. And I think Western countries have been under this illusion that they can and that they have a duty to do so ad infinitum. So just to get to the UK in a little bit of detail, their problem is the same as most other developed countries. They're letting in too many people, both legally and illegally. The consequences are a loss of societal cohesion, a loss of a sense of what it is to be British. There was a politician the other day who was saying, you know, it's about having a cup of tea and a pint and, you know, kind of being good people together. I thought, really, no, that's not all it is. It has to be something more than that. It has to be some shared sense of destiny, some shared sense of values. And if you admit too many people who do not share those values, and many immigrants do. Many immigrants are assimilable and assimilate. I happen to be one myself. I didn't come to this country and say, hey, you guys have to be more like me. I came and I figured out how it ticked. I read its founding documents and its history, and I signed on. And when you look at the big picture in the UK, it is, right now, they are unable to assimilate at the pace of the influx. They're unable to teach people the values, whatever they are, that make people British. They don't have a written constitution like we do. They've got case law, they have custom, they have tradition. People have a certain way of doing things. If you go to Britain, people get in line, they queue, they call it. You go to another country, not that far away, people don't queue. They just all kind of go up to the counter and clamor. That's just a different way of doing things. So when you get there, you look and you see people are in a line. I'm not going to cut to the front of it. I'm going to obey their traditions. And if you get to a developing country, and I've been there, and you try to get in line, you're never going to get served. So you have to adopt their values. Just to look at a few statistics, they had 34,000 people arrive by small boats just this year. And I believe they're going to hit at least 40,000 by the end of the year. They have about 48%, almost 50% of their asylum claims are approved. And between 2020 and 2024, there were about 96,000 asylum claims that were refused, and only about 25,000 of them were enforced. So they can obviously, if they wanted to, they could make that process quicker and they could deport the people who are supposed to be deported. But it's still, getting back to my original point, does not solve the essential problem. And then they could also amend their national laws, which actually mirror the ECHR. The ECHR, I found, the European Convention on Human Rights and the European Court on Human Rights, it doesn't actually deal with all that many cases from Britain. But the problem is that the principles in it, this Article 3 and Article 8, the right to family life in particular, are embedded in British law, the way our 1980 Refugee Act incorporates the Geneva Convention on Human Rights. So you're seeing now the Reform Party and the Conservatives, to a large degree, have realized they actually need to change the laws, which fortunately they can do because Parliament is basically sovereign and doesn't have the same checks and the filibuster the way we have here. I have a whole list of crimes committed by people who were either claiming asylum or had been granted or denied asylum. I mean, the list is too long to read out loud, and this is just from a few minutes of compiling, my own data. It is surely reaching the point where voters are taking notice and realizing that they have lost control of some parts of their country. The crime rate has, and I don't tie every increase in crime to immigration, that's too simplistic, but I do not think it's a pure coincidence that the rape rate in the US has gone up by 8 times since 2000. I don't think that's a pure coincidence that they have also taken in a very large number of single men from countries where there are very, very high rates of violent crime, particularly crime against women. I think there is a clear link in the data in Germany and in Denmark. There have been studies done that show this. In Britain, there are lots of appeals. Just like here, you can slow the case down. There was an old saying in the Immigration Naturalization Service, the case ain't over till the alien wins. And everybody was resigned to it because they knew there was always not just the one bite of the apple, but the second bite and the third bite. I did learn yesterday that appeals aren't quite as common as you think, and so it doesn't raise the number of total asylum wins by more than about 1 or 2%. But what it does is take a lot of everybody's time and waste an awful lot of government money. And some of these cases, I won't read you what I grouped them under here because it's not fit for broadcast, but some of these decisions are nuts. To give you one, there's an Eritrean who came on a small boat. The government was trying to deport him under this new, somewhat idiotic plan, with France, where they get one in and they send one out. I don't quite understand how that math. It's back to my infinity equation. But he gets his deportation withheld, whatever, stopped, while he gets to claim that he was trafficked. So you can pay a smuggler to traffic you to France and then over to England and then claim that you were trafficked. There's something wrong with that equation. We have a similar thing in the U.S. that we could talk about it at a different time. There was another case where an Iraqi claimed asylum in 2021 because he proposed to some woman on TikTok, and he thought that would make his relatives mad. He didn't actually win at first instance. He lost, but in an immigration tribunal, which is the first appeal level, he actually did. He had his case kicked back down for another hearing. So maybe he gets to win, maybe he doesn't, but he's still in the UK, digging roots. Another case, an immigration tribunal ruled that it would be unduly harsh to deport an Albanian, and it's a long story, basically because his 10-year-old child was special needs, and the case that made the headlines was that he didn't like chicken nuggets that weren't from the UK. And in the end, I learned that case was actually overturned, so who knows, maybe one day he will be deported. But it captured headlines, and it wasted a lot of everybody's time. 2 more cases that I learned about recently. An immigration tribunal ruled that an Afghan who has a complicated case, but basically got asylum after lying about his age and various other things. Maybe he had a case, maybe didn't. I wasn't there to judge it. His relatives who are in Turkey as refugees, they applied for visas to go to Britain to visit him. And they were denied because obviously they were going to claim asylum and remain indefinitely in the UK. A judge overturned that and said, yes, they have a right to visas to come to the UK, even though the judge admitted that they were not likely to work because they didn't speak any English and they didn't have any skills, and they were almost certainly going to claim public benefits and asylum immediately on arrival. If you extrapolate that sort of suicidal empathy, I'm sorry, but your country crumbles sooner rather than later. So there's another case, just quoting the judge in that one, the relationship between S, the Afghan who's in the UK, mental health and his contact with his family is at the heart of this claim, is what she said. He will, absent the support of his relatives, be unable to develop as an adult and live a meaningful life as a productive member of society. His wish to train as an electrician, which he hasn't actually done, has been sabotaged by his own inability to cope, and in his present mental state, he's unable to study. He believes that the presence of his family will give him the strength and motivation he needs. So this guy who is unable to study or get a job needs his 7 relatives, why not 14 or 25, to come to the UK to hold his hand while the government houses them, feeds them, takes care of them, so that he might possibly be able to complete training and one day get a job. This decision, even in the UK today, got some attention from politicians. So the law, the underlying law upon which this judge based her decision is what needs to be changed. Because judges have to go by the laws that are on the books. I mean, they do sometimes make stuff up, but eventually it gets to the Supreme Court and the Supreme Court puts them back in shape. So I would argue that nothing short of a wholesale revision of British law, a pulling out of every international, because remember, you can get out of anything you can get into. There are ways, I looked it up, to get out of the Geneva Convention. There are ways to get out of the European Convention on Human Rights. And at a certain point, you can accept that the circumstances under which you signed these documents are not those of 1951. It is no longer a question of Jews fleeing Nazis or dissidents fleeing communism. It is now about economic mass migration. I think we all know that in this room. So what we're going to have to see is a determined government in the United Kingdom, which, let's face it, is more likely to be one from the Reform or Conservative parties than the Labour Party. Although, as someone pointed out, Denmark, the Mette Frederiksen government, are they Social Democrats? I forget the exact party, but they're left of center. They made the decision to basically steal all of the policies of the Danish People's Party about immigration, and then their popularity went up. They won the election, and the Danish People's Party, I think, went from polling 25% to polling 2%. So it's not inconceivable that a Labour government could adopt the policies that are necessary. But frankly, given the coalition that they rely on to get elected, I don't see that happening. I'll just leave it at there and perhaps take some questions.
Thank you, Simon. So I'll give a minute about Israel's situation, and then I'll pass it. Maybe you can recommend according. But just to explain how absurd the situation in Israel is, Israel has no constitution. It's a constitution assembly wasn't able to get to agreement, so they said we'll pass the power to the Knesset, the parliament. And the Knesset over the years has not instituted a constitution, but they've put these what's called basic laws that passed in regular majorities, and it was never stated that they are a constitution. 30 years ago, the court decided that those basic laws are constitutional, have constitutional power, and since those basic laws have constitutional power, it can strike down regular Knesset laws, although it's passed by the same body in the same majority in the same process. So the same parliament can pass a constitutional law, and if the same body passes a law that contradicts that basic law, then it can be struck down by the court. Over the 30 years, the court said always that the parliament has the constitutional power, so if they don't like our decisions, they can always change the constitution. The first time, that happened right 2 years ago, but the first time the Knesset tried to amend the basic law and limit the court's power by a tiny, really like this minimal law, the court said that it's an unconstitutional constitutional amendment and struck it down. So right now Israel has an all-powerful court, more powerful than Louis XIV, that had to have some kind of coalition, and it can do whatever it wants. Back to you, my friends. All the case studies you brought talk about some kind of form of courts going rogue. What, if you had to pinpoint what can be done, what's the most important thing to be done, and what can be done if courts do go rogue and there's nothing that can be done on legislation? So what would you recommend, each on his own subject, not for Israel, but it could be interesting to hear. So.
It's a difficult problem because I think there's been a cultural divide, and so there are a group of people, most of whom the people sitting in this room would probably say they were part of, that believe that the Constitution is a fundamental basic law that's supposed to serve as a lodestar, and that is a reflection of the moral traditions as well as the political traditions of the country, and that this should not change. And we have another group that believes in this absurd concept of the living constitution, meaning that the constitution is supposed to change with the times in order to reflect how society has become different. But of course, if a document is living and you can change it whenever you want, then it's really not constitutional. And so part of the problem, I think, is cultural. People no longer understand what the courts are supposed to do here in the U.S. Most of the time when the media discusses legal issues with people, people are under the mistaken impression that courts are just sort of general purpose umpires for any kind of social, political, or other dispute. And so you hear people regularly say things like, well, you have to realize that in the United States, anyone can sue anyone for anything. That's not actually true, but that's what's happening now because the courts will do things like go back and visit the issues that came up in Trump v. Hawaii. And part of it is part of the sort of overall problem that I think is the reason why we're having this conference. Nationalism has become unfashionable, and so saying that, hey, listen, we don't do these things this way because we are the United States and the courts serve this function according to the constitutional order has become unpopular. And when it comes to immigration, you throw in an emotional component to it, and then you're being mean to the oppressed peoples of the world. And you have a giant problem. And so, not to give too much credit to dear Alexei, but he was also the person who talked about the tyranny of the majority, which is a widely misunderstood quote. What he was talking about was not the majority tyrannizing the minority, but the majority being created by people being sucked up with the kind of general cultural and political zeitgeist and not thinking for themselves. And so, sadly, I think he was prescient, and we're there.
Short, what do you think? If you had to offer, what can be done? And would you support the executive branch not complying with court's orders in some cases?
Well, that's been tried. Andrew Jackson did that. That's kind of a difficult thing even to address as a lawyer because it's a violation of your ethics as a practitioner of law. But at some point, it's incumbent upon Congress, I think, is the primary thing that can be done to fix it, to do what they're elected to do, which is pass laws. And so some of these things like asylum, well, we don't give asylum under U.S. law to people who have been the victims of domestic violence or crimes. That seems to be the way a certain subcomponent of the population here in the United States wants things to go, but they didn't change the law to accommodate that. President Obama just sent signals to the various agencies that they wanted this. The immigration bar picked up on it, and as an immigration judge, I barely heard anything other than asylum claims that were based on crimes and domestic violence. When I first started practicing immigration law, if you had attempted to bring a claim like that in front of an immigration judge, you would have been laughed out of court. They just would have simply said this isn't covered. So I think instead of everybody doing things by policy and by executive orders, we need the government to run with a separation of powers the way that it was designed to, for the legislators to legislate, the executive to enforce, and for the courts to make decisions about whether the law is being applied appropriately. And we have gone off track.
Thank you. Victor?
Well, I'm very, very pessimistic about this, and I tried to explain why. So the first thing is that in the case of, for example, this Hungarian penalty and Court of Justice, it's the ruling of the Court of Justice of the European Union, like the ruling of God. So the story is over. So and as I mentioned, everybody was surprised about the decision, and everybody was shocked. Not only Hungary, but commissioners, etc. So, but after the shock, everybody started to thinking in Hungary, okay, what's the next? So, paying, changing a regulation, I think, and the decision was that they started to calculate. So, is there any possibility for negotiation with the Commission to say, okay, now the Hungarian asylum system is okay for the EU standards? And it was clear that no, because it's a cat and mouse game and a political game. So, okay, what's the cost? What would be the cost if we if we do everything, each regulation, so they calculated that it would perhaps cost 10 times more for Hungary than paying this daily penalty. And of course, don't forget, it's also a political game, elections coming in April. You know, if the government would say, okay, we are losing immigration, you know, opposition would to tell automatically, oh, the government, you know, betrayed the case. So this is why it's so devastating to see it became a political game. And then other issue which highlights that the insaneness of the whole case. So Hungary got the penalty because it limited the access to its territory. It established so-called transit zones at the borders, because all we know, the real question is whether we manage to detain persons under the asylum process. Because if we not, catch and leave policies, they will disappear. So the Hungarian government established the transit zones. Asylum process was there for months, 1 year perhaps. And, you know, it's not possible to detain persons, asylum seekers, so long. So what was the Hungarian argumentation? That these facilities are open towards Serbia. It was on the Serbian-Hungarian border. Anybody if don't want to stay, just go back to Serbia. But the court didn't accept this argumentation, so Hungary had to close the transit zones. Now, in the new Migration and Asylum Pact, there is a part about border procedure, because everybody in the member states and the EU recognize that if there's no some kind of detention, people will disappear within 2 days in the European Union, and they will be at the La Manche Channel to go to UK, for example. But you know, it's the same transit zone what Hungary established, because the original idea that okay, keep these people, the border process at the border before they manage to get into territory of the European Union. So we can see in the next year, perhaps, that while Hungary is paying the €1 million because of the previous transit zones, we at the same time have to establish border processing centers according to EU law. And you know, it's according to the current regulation of the Commission, Hungary, a country of 9.6 million people, should be ready to process at least 8,000 persons at the same time. And okay, perhaps the United States, it's not a big issue, but the maximum capacity of the Hungarian transit zones were 800 persons the same time. So can you imagine, it's 10 times more. This is why the government started to calculate that, okay, we should establish a whole city to process if we will follow the regulation of the pact, the commission, and the court. So this is why at the end of the day, the government said, okay, no, it's easier to pay 1 million daily because it would cost too much, simply.
What if they raise it to 100 million a day?
Yeah, this is a possibility. And not to mention that there are new trials against Hungary, so yeah, we don't know, because and this is why there's no solution. You know, the government is thinking, you know, to go to an other court, you know, to make a lawsuit against the Court of Justice of the European Union. But you know, you feel how insane this whole situation. So, and this is why I'm telling that what we see now in the European Union, that the power and the institution past the critical mass, that it's very evident that Hungary alone can't stand too much, too long against this whole regulation. So at the end of the day, the back of Hungary will be broken. So the real chance is now, what was mentioned, that by in this report that we wrote together, Rodrigo, that if the member states makes coalitions, because if 9 member states say, no, this whole pact is insane, the ruling against Hungary is insane, perhaps it can lead to a change. Sorry.
Thank you. Simon?
Excuse me. Yeah, I just, as a side note, before I get to my big solution, I learned one thing about the ECHR that I didn't know before, which is that there's nothing in it about immigration. It's this idea of the living Constitution, which is what in America got us a right to an abortion that just isn't written anywhere in the Constitution. The European Union actually outright says this is a living document. It needs to change with the times, meaning we can make it do whatever we want. So they actually injected Article 3 and Article 8 into immigration law and started using it in a way that is, sort of defies intelligence, but it wasn't, that's not how it started. So I compare this to, when I was a kid, my mom said, she said, don't go north of Nassau Street on your bike. I got that aged 8. If she'd said, don't go too far, well, what's too far? It depends on my mood. Maybe too far is Kingston, the next town down the road. Well, that's kind of what the law needs to be. It needs to be really clear. If it's a living document, well, what does it mean? What's the right to a family life when we get back to the Afghan with the 7 relatives who get to come on a tourist visa? But my glib solution is that Gulliver from Swift's novel needs to realize that he's bigger than the Lilliputians and get up off the ropes and just do what needs to be done. 3 things. Number 1, you need a Rwanda plan. I wrote about this in a report pretty recently. You need an offshore processing model like the Australians have that says you cannot get asylum if you come into this country by boat or by plane, period. You have to go somewhere else. And then you have to have a process, and what I would suggest is you rate people. Instead of a yes or no, you give people a score on their asylum claim. From, the absolute, the Uyghur who was, or Jimmy Lai, from Hong Kong, if you know that case, he gets a 10 out of 10 in my book, if he wanted to, but he's a brave man and he chose to stay and fight. And then you have, a 1 for someone who's like, maybe, I don't know, there was a case made, but it's probably not a good one. And then you have a cap. And that's the part which is probably controversial. Once you have your ranking system, you say, okay, the Netherlands, the United Kingdom, whatever country has decided we can take 10,000, 50,000, whatever number it is, refugees or asylees, lump them together this year, and that is it. And then we go to our list. Who's got a 10? We go with those guys first and then work our way down. So I think that's what needs to happen, is those 3 things. It's going to take an incredible political lift. I'm not sure, frankly, that any country in Western Europe has the political stomach for this. If you look at the combined opposition and the entrenched bureaucracy in the courts, I'm afraid we might have crossed past the moment of no return. But that's what I think would have to be done to control mass illegal immigration under asylum.
Thank you very much. It was very interesting, very informative. Appreciate your time. It was great to be here, and thank you for the audience for listening. So, and lunch.